Inner. End of the season. Season ending.
Ending Lordship. 1 year is past.
Season ending. No presence of lawyers also. Yes.
Lordship, I would to mention for listing tomorrow, Lordship, interlocutory application.
Repeat it.
Interlocutory.
Ah.
Oh, IL of life.
Please, Your Lordship, I am appearing on behalf of Mr. Raj Chhetri. Your Honor. I am appearing on behalf of R. Chhetri. I beg to mention for adjournment of item number 3 of today's daily post list.
No need of adjournment. We'll issue notice. That's all. We will record your name. What's your name?
Mohit Pandey.
Mohit Pandey.
Yes, Your Honor.
Okay.
Hello.
May I please, Your Lordship?
You are legally counsel.
Yes, Your Lordship.
Where is your,
My name has not been shown in the cause list.
but where is your letter? Outside is here.
I have annexed in the main petition, Your Lordship. It is main petition.
Right. Miss Sangeeta Khatania appears for the appellant who has been convicted under Section 6 of the POCSO Act by the Court of the Additional Sections Judge cum Special Judge POCSO, Moregaon, in POCSO case number 31 of 2022, arising out of Jagi Road PS case number 435 of 2020. Admit the appeal, call for the TCR. Ms. A. Begum, APP appears for the state. Okay, issue notice returnable in 4 weeks. Huh? Appears for the state, then you write registry to send a soft copy of the appeal. So it is by you or what?
Yes, I
Made the appeal. So
Yes.
you will give it.
not.
You will give it to the right. The learned legally counsel shall give us a soft copy of the appeal to the office of the PP, who shall furnish the same to the concerned OC of the police station. The OC shall thereafter serve a copy of the same to the respondent number 2 and file affidavit of service thereafter. Respondent number 2 / informant.
I can also I for
Is the
suspect.
matter on forgivable date. Then you write in the IA, right, Ms. A. Begum is granted 4 weeks time to file written objection to the application under section 430 BNS.
Most of them.
Out here you write Mr. P. Kataki. Then out here same section 6
Same second.
by the additional section judge cum special judge POCSO Sipsagar in special POCSO case number 11 of 2024 arising out of Sipsagar PS case number 25 of 2020. Okay, same thing. You give a copy.
Yes, ma'am.
Out here it will be appellant's counsel, not
Yes, sir.
legal aid.
Only the TCR might call like what?
Everything will be same, ditto.
Dictum.
Item 3, you write same, everything same except will be out here. Mr. Mohit Pandey appears on behalf of Mr. R. Chetty for the appellant. Convicted under section 6 by the court of the additional session judge cum special judge POCSO Kamrup M. Guwahati. In session special case number 16 of 2023 arising out of Hatigaon PS case number 529 of 2022. Okay, same thing. I also same thing.
Hello, Blake.
No such person in this address. What to do, madam?
Lordship. 30 to 34.
302.
Yes,
So
my
not
lord.
required. Not required. Okay, right. As the paper book has not been received, registry to wait for the await paper book. No, as TCR has not been received, await
TCR arrived, your lordship.
TCR, right?
Yes.
Okay, as TCR has arrived, registry to prepare the paper book. Office note indicates that no person resides. No, indicates that respondent number 2 does not reside in the address provided. Accordingly, unserved notice of respondent number 2 has been returned back. Is it acquittal?
Oh,
Oh, this is acquittal.
oh, then notices, please. So they have to take fresh steps, your lordship.
And then you say, appellant to take, as this office note indicates that unserved notice has returned back from respondent number 2. With the postal remark, inverted commas, no such person in this address, inverted comma. No. The appellant shall obtain the correct address of the respondent number 2 and file the same within a month. File the same within
Arai Mandal.
No.
a month. List the matter given it.
Number 2, I can do slower steps, slower.
Nothing is.
No. So await service report in respect of respondent number 3 and 4.
Problem.
Give in February or something like that. No?
7. 2016, how many years later? Every day.
Hey, please, Worship. My lord, here is the case. The present applicant, who was the appellant before the Honorable High Court, jail appeal, he was convicted for life under Section 302 of IPC. Now, my lord, the parties somehow managed some money, etc., and went to the Honorable Supreme Court. At Honorable Supreme Court, lawyer have gone through the records and found that he was a juvenile on the day of occurrence. And there are plethora of judgments that
So you go to the Supreme Court. You go to the Supreme Court.
No.
Because we have already decided this matter
decided.
2016. We are not going to open it now.
Let me satisfy your lordship. Your lordship has decided the matter without going through the juvenile matter.
Naturally, because you did not bring up this
Yes,
subject. Now
that
it has
is-
been, this is a finished chapter for us. You go to the Supreme Court. Have you gone to the Supreme Court after this order?
No, we went to Supreme Court, but Supreme Court lawyer verified the
No,
judgments.
we are not bound by the Supreme Court lawyer's opinion.
No, we have judgments, Supreme Court judgments available.
Supreme Court judgments. We have
But
seen
High
it.
Court may kindly go through the judgments for a while, then also kindly decide. These are very important judgment at any stage, and High Court
Correct, at a stage.
and High Court, even if it was convicted, even then may reopen the case, because on the ground of juvenility, that was not asked upon at that relevant point of time. ক্রোধ করো এটা মহিলা
No, it দুটা বেলেগ বেলেগ হয়। দুটা বেলেগ বেলেগ।
এইটো নেই এটা নেই এটা একটা মহিলা
Yes, which paragraph?
Yes, Rahul Kumar Jadhav, that lordship may kindly see page 10, para 10 and 16. Para 10, kindly see. Rahul Kumar Jadhav.
Yes.
Indisputably, during the pendency of the appeal before the Patna High Court, the Juvenile Justice Care and Protection Act so-and-so had come into force, which provides a comprehensive mechanism to consider the prayer of juvenility raised on behalf of an accused claiming to be a child on the date of commission of the offense. The proviso to section 9(2) of the
Record.
JJ Act 2015 clearly enumerates that plea of juvenility may be raised before any court and it shall be recognized at any stage, even after final disposal of the case. The High Court, however, did not consider that and decide the prayer of juvenility raised on behalf of the appellant. There are catena of decisions of this court which hold that the plea of juvenility can, even if not taken before the trial court or the High Court, can be raised before this.
Be raised before the, can be raised before, just carry on reading,
My lord.
complete reading.
No, completely, there are 10, then 11.
And just read again, please read again.
There are 10 minutes.
Yes, yes, 11.
11. There are catena of decisions of this court which hold that the plea of juvenility, even if not taken before the trial court or the High Court, can be raised before this court.
So,
No, that is one of the judgment. Other judgments, lordship.
go to Supreme Court.
Now kindly take another state of Madhya Pradesh judgment.
This is Supreme Court judgment. You raise it before Supreme Court.
That is all.
That's what. It says here, if it has not been raised before the High Court, you can raise it before the Supreme Court.
Now that may be raised, but High Court is not barred.
No,
That-
no, maybe it be, but you see, we have decided this judgment, this case, in 2016. In 2025, why should we order?
That is, but
On against the judgment passed by this High Court before the Supreme Court. Have you ever gone?
we did not
You
go.
have not gone. You have not. If you have not gone, now you can go.
No, we can go, but when the way is available in High Court,
No way is
Why
available
the-
because in your 313 recording, your age is of 25.
my lord, let me kindly see state of Madhya Pradesh judgment, para 11.
Yes.
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 It is noted that in respect of the incident dated so-and-so, the applicant was convicted on so-and-so by the special session judge Hind. Thereafter, he was acquitted by the High Court by judgment dated so-and-so. Subsequently, in the appeal filed by the respondent state, this court by judgment dated so-and-so convicted the applicant. It is therefore thereafter that the applicant has undergone sentence of 4 years and 3 months in all. Subsequently, this miscellaneous application was filed and this court by order dated so-and-so directed that the inquiry be conducted. Subsequently, the learned session judge has passed his order on 16/7/24 and has submitted his report to this court. Pursuant to the order of this court, on 16/5/24, the applicant has been released on interim bail. Therefore, on perusal of this report, we note that not only the applicant herein, but the mother as well as headmaster of the school have been examined as PW 1, 2, and 3, respectively, and as many as 5 documents were also considered by the learned session judge. It is on consideration of the same and having regard to the section 94 of the Juvenile Justice Care and Protection of Children Act 2015 that the learned session judge found that the applicant was below 18 years.
Please, based on school certificate. Would be.
So, my lord, we're here. We're here, my lord. The session judge was directed to cause inquiry.
Directed by whom?
Uh,
Session judge was directed by whom?
That was directed.
Directed by whom?
Here we have also.
Chief Minister, Chief Secretary, by whom?
No, that is
The High Court or by whom?
it was directed by Supreme Court.
Ah. So,
But
you're answering your own question.
no, I am answering. But thing is, this High Court's power is not taken away. High Court will say or simply to inquire the matter whether he was a juvenile on the date of occurrence or not.
Go to the Supreme Court because you have not availed of your remedy before the Supreme Court. You go there. There is no bar. Like you said, the judgments of the Supreme Court are there to help you open up this issue. You go there. So either we dismiss your case or you withdraw and file appropriate proceedings before Supreme. Please, you have
No,
not
my lord, my withdrawal may not be sufficient for me because at that time they may say High Court would have done this, why you have withdrawn. So Lordship may kindly observe all these judgments and then party may approach the Honorable Supreme Court. Kindly do this.
We are not going to tell you to approach the Supreme Court. We are going to dismiss it. That's all. But if you want to withdraw to approach the Supreme Court, that we will allow. But we are not going to allow you. We are not going to make a petition for you. That much be.
Then, my lord, after discussion of this citation, this may be dismissed. Otherwise, Supreme Court, if you withdraw, that there may be a question.
Correct. We'll hear you. No problem. Yes. I think we'll dismiss it. That's all.
Let him withdraw it, my lord.
He doesn't want to withdraw.
Withdrawal may bring some problem for me.
He doesn't want to withdraw.
Supreme Court may say that you have not pressed the matter.
Okay, it doesn't
And
matter. But
my-
then it might not
My
be.
limited understanding that I think that Honorable Supreme Court may again send back the case to.
That is all right.
Anyways.
Right now, it is functus
If
officio.
I
We are
withdraw that-
functus officio.
If I withdraw that, I may be debarred from that benefit. That's why I am saying Lordship may discuss kindly our submissions and then Lordship, if please either grant us bail or dismiss it.
No, dismiss it.
Bail.
100% dismiss it. We have to dismiss. We have got no choice. Because you have still got a remedy available with you. That's what you. Anyway, right. But Mr. M.U. Mahmood, learned counsel for the applicant, and Miss B. Buyan, learned senior counsel and APP, assisted by Miss Idas
Hard, my.
Arda. The applicant has submitted this application.
Two applications. One is for bail, another is for
Just a minute.
causing inquiry.
But we are taking up this matter. Has prayed for, has submitted this application, praying for. Praying for what?
Petition number, then I can say.
Praying that he should be declared a juvenile. Praying that the applicant should be declared a juvenile within the meaning of section 2 bracket K of the Juvenile Justice bracket Care and Protection of Children bracket close Act, 2015, as amended up to date, hereinafter referred to as the 2015. No, full stop. The prayer has been made on the ground that on the date of occurrence, on the date of the murder of the deceased on 3/8/2009, the applicant was 17 years, 9 months. And thus not a major. Next para. The applicant's counsel submits that the what have you said about this school certificate? Nothing.
Only that indicated.
There's no para 11.
Is annexed to. So. Page
Ah.
6, para 3.
Submits that this fact that the applicant was not 18 years, had not attained 18 years on the date of the incident came to his knowledge only now and was never placed before the learned trial court or the high court in appeal.
But a little
Full stop.
minor correction. Actually, paper was given to the learned counsel, but he did not raise the issue.
No,
We
that
have
is
the
not there.
knowledge.
That is not there. Sorry. You cannot say what you want. There's no such pleading.
Yes, that is true.
The learned counsel, next para, the learned counsel for the applicant submits that the age of the victim can be gauged from the
School certificate.
LP school from the LP school leaving certificate dated 6/1/2000 issued by the headmaster of Kota Madhya Para LP school, page 42, which shows that his date of birth was 1/11/1991. Okay, next. The next para, the learned counsel for the applicant submits that in terms of the judgments of the Supreme Court in the case of Rahul Kumar Yadav, is it? No.
Yes.
Rahul Kumar Yadav versus State of Bihar. Criminal Appeal number 214 of 2018, comma. That is number one, Rahul Kumar, number one. The number two, State of Madhya Pradesh versus Ramji Lal Sharma and another. Criminal Appeal number, miscellaneous application number 261 of 2024. In Criminal Appeal number 293 of 2022. Plea of juvenility can be raised before any court at any stage and even after final disposal of the case. First up, he submits that the learned trial court had disposed of disposed of Sessions case number 121 of 2010 by judgment dated 9/4/2015 by convicting the applicant under section 302 IPC. Full stop. The appeal filed by the applicant before this court by Criminal Appeal 57 bracket J of 2015 was dismissed by judgment dated and order dated 30/8/2016. Next paragraph. The applicant's counsel submit that no plea of juvenility had been taken by the applicant before the learned trial courts or before the High Court. It is only in the year 2025. Correct?
Yes.
When? In the 2025, that the applicant has come to know of the
No, no means, when the-
LP school certificate showing the applicant to be born on 1/11/1991, which would have made him a minor at the time of commission of the crime. He thus submits that in view of the LP school certificate, the applicant should be declared a minor at the time of commission of the crime. Next, Ms. B. Buyan, the learned APP, submits that this court has become no, one more thing, right? May the applicant's counsel further submits that no appeal has been filed by the applicant against the impugned against the judgment and order.
Lordship,
Date
sorry to interfere, my lord,
38,000.
sorry to interfere. Lordship, probably Lordship may interfere with, because Lordship, there are judgments, my lord, at any stage. If your
No,
lordship
no,
wants
no,
to
no,
stop,
no, no,
then
no. It will not be proper. Not after 9 years.
9-2, my lord.
You see, one thing I tell you, no, madam, you just see one thing. You are saying it without reading the file.
No, yes, I'm so sorry. I don't have any
Yeah,
papers also to
You
be
don't
frank.
have, that's
Yes,
why. You see, when you look at his 313 statement,
my lord.
his 313 statement is at page 36. Now, he was 25 years on 14/12/22. 2012. So in terms of this, he would have been in 2012, he was December 2012, he was 25. So he would so he was born 87. 80. So,
Under 9-2, my lord.
huh?
Under 9-2 of the Juvenile Justice Act, any stage the lordship may interfere. That's the lordship is aware of.
Correct.
Yes.
No, but now since he still has got one avenue left.
Avenue. That may be on that ground.
Because
yeah, my
no,
lord.
because when you read the Supreme Court
No, no.
judgment, you have not read it properly, I think.
I've not come
You
across.
say in this para 10 or 11 also, it says this court directed the inquiry be conducted. The Supreme Court.
Supreme Court did.
Then in this other judgment, it has been said there are cantina of decisions of this court which hold that the plea of juvenility, if it had not taken before the trial court or the high court,
Lordship.
can be raised before this court.
That's
So
true,
let
my
him
lord.
raise it before the Supreme Court.
Let him raise,
That's what.
but lordship, I am not aware of whether, probably in those matters, they have not taken the plea before the High Court.
They've not taken here also.
Yes,
That is
now
what-
they have taken.
They have taken it
Now.
after 9 years after we have become functus officio. We can, you see, first of all, there are various aspects. He has not come under any provision of law. He's just come under that. He has not come under the CRPC or the BNSS.
My lord.
He has not come under the BNSS.
Lordship.
No, I have quoted sections.
He have quoted sections
Yes.
of which law? Of the 2015 Act. You have not quoted the BNSS.
That is as amended, but earlier it was 2003, I think.
You see, to file an application, you have to come under some provision.
The provisions are mentioned here, man. For your ready reference, kindly see
The 2015. You have only applied under the 2015 Act.
Prerequisite.
Now,
Taking
2015.
reference of Honorable Supreme Court's order.
No, but how, but can we do it now at this stage?
It is up to your lordship.
You see, you have to come under our inherent powers.
My lord.
Otherwise, how it is done?
Lordship, but 9(2) specifically says this delay is not a bar. Lordship,
9(2) off?
yeah,
At
9(2)
any
JJ
time.
Act.
Detect.
Yes, so Lordship.
No, but
I'm-
no.
Can it be taken up in the after the holidays?
No. Why?
I want to see the provisions of law, Lordship, so the law.
We'll take it up tomorrow. We'll take it up tomorrow. We'll take it up to.
Fine.
Huh? We'll take it up tomorrow.
Fine.
You
Whether after delay can be a ground, Lordship. Yes.
you see, Supreme Court under 142 can
Extensive,
complete justice, it can
Yes.
do it.
my lord,
But for us, now supposing, now this is of 9 years.
my lord,
Supposing there's a case of say 25 years.
Lordship,
You see, there are many aspects.
my lord.
You don't take one.
My lord, actually, in this case, we have also filed a condonation petition, but the registry said it may not be necessary. So it is kept on record. Kindly see.
No,
that is also
we
there.
are not on that. We are not on that.
So
You see, if
delay is not the matter here.
no, you see, the thing is that you still have got an avenue left.
Yes,
That
that-
your Lordship is very much correct.
That is why
I am
you
afraid your Lordship, since they have not withdrawn it, they may take a plea that Lordship did not interfere with the order of this one, as regards juvenility. And Lordship, it may not be, it may be a wrong order.
we are going to say that because he has not filed an appeal, he always has got the
Leave it to your Lordship, my lord.
scope to leave it. No, scope to go to the Supreme Court.
Why not?
Let him go and agitate there.
Lordship.
Otherwise, we will put in also, we will say somebody comes
My
after
lord.
30 years. Then what happenens?
When the High Court has some power, parties should not be pushed away to the Supreme
No,
Court.
but
So on that, let it become tomorrow. I will satisfy whether High Court can entertain or not.
no, not on that, not on that.
Lordship may indicate
nothing,
in
I
the
don't-
order, observed in that
I
order.
don't think there is any order.
No, we have also another High Court should also interfere. We have let it be fixed tomorrow.
No, no point.
Then I leave it to your Lordship.
You see, we do not find why should we entertain this application when the remedy is already there?
But my submission, why your lordship would not entertain when the law permits so?
No, not after 9 years. There has to be some limitation period.
No, at any stage, it is said in the legislation.
আর একটা judgment আছে I got to theta আছে I got to theta আছে এই যে I got to আছে
That will cut.
এটা তো পুরানো না এটা 23
And not only that, now when you go to the merits, when you go,
My lord,
he read at Madhyama LP School education to ended 35. He passed examination, ABC degree, his date of birth is 1st November 1991. Okay. So according to the his age is
এটা আর একটা নাই
now, if he was born,
এটা আর একটা আছে অর্ডার কপি এটা
if he was born on
এটা ব্যাক 5 on
1999, his date of birth, the 1st November, if it was issued here, it would not have been, no, date of birth is this, sorry. No, according to his age, as on this day, would have been, would have been 9 years to 5 days. Nothing is there. So nothing available with the.
proviso to
Huh?
section 9(2).
Hmm.
Provided that such a claim may be raised before any court and it shall be recognized at any stage, even after final disposal of the case, and such a claim shall be determined in accordance with the provision contained in this act and the rules made thereunder, even if the person is ceased to be a child or not before the date of commencement of the same. So in that even of the matter,
9 of the
9(2), proviso to 9(2) of JJ Act 2015.
2015.
So I'm thinking twice, my lord.
Okay, we will not record yourself.
No, my record may be submitted, but lordship,
Let us see the 2015. We've got time.
yes,
There's no hearing.
less matters to do.
No, I have one judgment, Lordship. Makkela Nagaya, that is 2023, 9 SCC. My lord may kindly see para 6, page 809. Here, my lord, High Court is, the High Court of Andhra Pradesh has forwarded the report of the second additional session judge Khammam on the issue of juvenility of the petitioner. In the report dated so and so, the second additional session judge Khammam has categorically come to the conclusion that the date of Makkela Nagaya is 2589. The report is based on a detailed examination of documents, so and so, coupled with the oral evidence of witnesses, so and so. We have no hesitation in accepting the same. So High Court sent the matter to the learned session judge. Session judge inquired the matter.
That's all right. That's all right. That also we would have done. But the issue they have come under after 9 years.
No, it is a Supreme Court's order. Supreme Court's order is that
What has sent it?
Supreme Court has discussed the matter and said that High Court is also empowered to send to the no after conviction. After conviction. In view of section 16, that is, I'm 2023 9 SCC 807. In view of section 16, read with section so and so of the Juvenile Act, the maximum period for which the petitioner could have been in custody is 3 years. However, as the plea of juvenility was raised for the first time in the present writ petition, the process of criminal law, which commenced in 2005, led to the petitioner being convicted and sentenced for life imprisonment concurrently by the trial court, the High Court, as well as Supreme Court. In the meanwhile, the petitioner has undergone more than 12 years of imprisonment. Thus, the petitioner can no longer be incarcerated. That means he cannot be kept in jail. Now, I have crossed, my lord, 10 years, 7 months. Perhaps today, this month, it is 8 months. 10 years, 8 months. So my prayer, my lord, humble prayer was that Lordship may kindly send the matter to the learned session judge, Bajali.
Lordship, come across Narayan Chetaram Chaudhary, State of Maharashtra, para 20, may I read? As regards maintainability of the present application under 9(2) of this so-and-so act, in the case of Hariram, next second, Hariram versus State of Rajasthan and another, which authority was quoted with approval of Abdul Razak versus State of Uttar Pradesh, it has been held that claim of juvenility may be raised before any court which shall be recognized at any stage, even after final disposal of the case. In Vinod Katara versus State of UP, the rationale for raising belated claim of juvenility has been explained by 2 judge bench of this court. Harira, can it be taken up tomorrow? Then Manu will go through it.
Yes,
Other judge-
that-
Let's go to, we've got time.
Yes, or today, no? Yes. Etu kaun hai ke? Court. Etu petition to dio. AR 2023 pabo.
It starts mainly from the judgment of 2012, my lord. Abu Jor Hussain, 2012, 10 SCC 489. Here first raised and all the subsequent judgments has quoted this judgment.
Let us see the judgment you said. That Nakala you said.
Nakala I have given. But my lord, I am sorry, backside there is no.
Move to do. Narayan Chetaram Chaudhary. 3 judges bench.
McKellar. McKellar. नाम एक बात है कि नाम दो क्या करना एक उद्योग सुविधा के खाली नहीं पता है
Pasal, kita ni kita pasal ni. Foto? Nah. Two factors may come in. They have not challenged the order of conviction before the learned, before the Honorable Apex Court. Then in the event he is declared a juvenile, then your lordship will be reviewing so not on the point of
That is what,
juvenility.
we are basically will be reviewing our,
Yes, my.
since he has not challenged it.
My lord.
No, no.
Go to,
Let him go to the Supreme Court and no, no.
let him go to the
Lordship.
Supreme Court because that
My
will
lord.
have an effect on the entire.
Yes. In Narayan Chetaram, that point was also observed. He has not challenged the order of conviction. His three judges bench decisions.
And it cannot be challenged here. Though you have raised an interesting point. The problem is it is 9 years of it. No?
No, we have not challenged the judgment, my lord.
That's why.
We have
No,
taken
no.
the plea of juvenile.
Juvenile
But then that is,
knowledge.
yes, the judgment to his, the conviction to you don't need to challenge.
Yes, no, I have not challenged.
Conviction you don't need to challenge because conviction to his, even if he's convicted 3 years.
Yes.
But down to, supposing we find that you are a juvenile.
Juvenile.
That may be inquired into.
We will have to modify the order.
Yes.
We'll have to modify the.
No, my lord. That modification may not be necessary. Let me submit, my lord. If your lordships kindly send the matter to the learned session judge.
We'll have to modify. We have to
But
send it
yes,
to
For the inquiry,
still remain. Your lordship's
Continue to
earlier
the board.
order.
my lord.
Your lordship's earlier order still remain.
Yes.
And this code would be functions officio in the event of the matter he's a juvenile. Those factors will come in. Let him approach the Honorable Supreme
Yes,
Court.
I think that's the best. Otherwise, we are going
But
to.
if the High Court has power, why a poor lady who cannot even file appeal since last 8 years she should, even after High Court judgment 8 years she could not go there.
They say
You
they
are-
have,
She-
yes.
She collected.
They are,
We will take up your matter. We will direct that the SLAC should send
Yeah.
your matter to the Supreme Court. With the paper book, we'll direct.
on the advice of the Honorable Supreme
Direct
Court's
that.
lawyer, they have come up
If
again.
you want, we'll direct that. We'll direct, after we dismiss your petition, we'll give a direction in this application that your case should be taken up by the state SLSA and an appeal should be filed by the state SLSA against the said thing, keeping.
A timetable then lordship may kindly. A short timetable.
Timetable to we cannot give the Supreme Court.
Because already I am nearly 11 years I have been.
Free to give timetable to Supreme Court. We cannot give time. We can tell the SLSA to do at the end. We can request it. It's
Or as early as possible that.
naturally. Because to do it,
Actually, my lord, my
If this, without going into these controversies, if you withdraw this plea,
Yes. Should be
you have
proper.
raised a plea of juvenility. And then we'll say that it not being, the matter have been disposed of. You can withdraw it with the plea that you will raise it before the
Honorable Supreme.
Supreme Court along with a challenge to that
Yes.
judgment. Then we grant you liberty, we
That-
allow you to withdraw.
I understand that. I respectfully submit your lordship's view. I desperately have sufficient, but I think there may be a question of technicality that you have withdrawn the case. You have not.
The technical.
no, there's
We-
a-
It will be remanded back to us. We get our jurisdiction to consider the matter.
Withdrawal, it will defy.
You see, one thing I'll tell you, there is no delay in a criminal matter. The other day, we, all over India, all the conviction, the appeal against convictions which have been rejected by the High Court have been sent to the Supreme Court to be taken up by the legal aid process there. Old one, new one, everything. So wait a minute, maybe your case is also sent to Supreme Court.
2016 matter.
We will
All
have to
likely
find
to-
out. I'll have to find out. It already, might already be sent to the Supreme Court. I'll find out today. I'll find out by lunchtime.
Nothing withdraw to it.
Just ask Devaki.
Whether this case can be sent to Supreme Court?
Huh?
Already your case.
This case?
No.
No,
we are
criminal
going
appeal.
to.
Conviction.
Order.
No.
No, conviction I am saying, because in juvenile act only maximum sentence is 3 years. I have already in nearly 11 years.
Conviction sir.
38
Supreme Court পঠিয়াই দিছে on their own right based
passed in criminal appeal J, number 57 of 2015. Azuruddin, number 2 is Ayub Ali, number 3 is Rahela Khatun, number 4 is Faisal Haq. Was the state of Assam?
They have been repeatedly wanting.
Okay, only this Azharuddin, Azharuddin. ASU. UDDI.
Single.
What's
He
the
is
state of
only
Assam?
one country.
Just find out. Just has this been as the appeal has been for a brief has been featured in the party has been remember how you can ask the registry here.
Into first time edition data bomb edition has a reject High Court to the latest file calling reliever allow direct decision on the inquiry each single mention.
Then we'll.
My lord, my junior has found one judgment. And the
Single.
petition was filed before the learned session judge to examine the matter of juvenile willing. Then learned session judge rejected that petition that it was not earlier raised. Then the party came to the Honorable High Court. My Lord Justice Sharma sent back the matter to know the order passed by the learned session judge is wrong. He may go through the matter. So that is single basis, of course, single basis order.
No, but whatever it is, no, but then that will already been taken by the High Court. How is it to?
High Court has taken the matter.
High Court conviction to appel to restore.
High Court upheld the sentence. High Court upheld the sentence. Then the matter of juvenile liberty came. Then they filed a petition before the trial court. Trial court rejected on the ground that it was not raised earlier. Then party came to on criminal revision petition. High Court said that it is wrong. You go through it. And again,
What's the criminal revision number?
451/2017.
451 of
2017.
order dated.
criminal revision.
Yes, ma'am.
Can you take it out? Criminal revision 451 of 2017.
Order dated.
2012/2017.
2017.
Yes.
Same person.
No,
No, my lord, it's a different case.
What? Oh, same, what? How does it have? So what is the connection with this case?
The ratio is the same.
Thereafter, they went before the Supreme Court and this clear. Supreme Court rejected it. They came up on. Put this court in an.
In that case, Supreme Court, they did not go.
Yes.
They came to High Court upheld the sentence. Then they filed petition before the learned trial court. Kindly go through this. Then trial court rejected this. Then they came to criminal revision and the High Court sent it back to the.
So the appeal had been already rejected.
Appeal was rejected by the High Court.
In the appeal, my lord, the Honorable High Court upheld the order of the learned trial court. Thereafter, the person came to know that he was a juvenile. Then an application was moved before the learned additional district session judge. It was rejected. Then, my lord, he filed a criminal revision petition before the Honorable High Court. Honorable High Court observed that the person has not approached the Supreme Court, but even before the High Court, it was not raised. But later on, when he came to know that he was a juvenile, he moved an application before the learned additional session judge, my lord. There it was rejected, and then he filed a criminal revision petition before the Honorable High Court.
And what did the High Court say?
I could say that the plea of juvenility can be raised at any stage.
What have we said?
It was a reported case.
Passed by this court.
2019, 3
Yeah.
GLR 351.
Criminal appeal J number 57 of 2050. As of
Forward it.
And it is the number yes.
451.
It is a reported. It is a reported case. I am giving the
2017.
reported case. Giving the yeah. Order dated.
You're right. The
jailer, no?
Supreme Court in the case of Rahul Kumar Yadav. Supra had held that. The proviso to section 9(2) of the 2015 Act clearly enumerates that the plea of juvenility may be raised before any court, and it shall be recognized at any stage, even after final disposal of it. It further held in para 11 of the said judgment that even if the plea of juvenility is not raised before the trial court or the high court, the same can be raised before the Supreme Court. In the case of Ramji Lal Sharma Supra, the Supreme Court held that despite the conviction of the by the Sessions Court having been upheld by the High Court and the Supreme Court, the miscellaneous application claiming juvenility was directed to be inquired into by the Supreme Court. It submits that in view of the above decisions of the Supreme Court, this court should direct the trial court to conduct an inquiry with regard to the claim of juvenility made by the applicant in terms of the LP school leaving certificate dated 6/1/2000 issued by the school. We have heard the learned causes for them. The application of the applicant praying for declaring him to be a juvenile has not made any mention as to when, as to why he had not taken the plea of juvenility on the basis of the school leaving certificate, which had been issued even prior to the murder having been taken. That is on 6/1/2000. Whenever I said it. Gustav. No. The murder taken place, that is when we cut that death. The no reason has been, no explanation has been given by the applicant.
My lord,
As
before
when the
lordship's concluding is still
As
there.
to when the LP school leaving certificate. To end the LP school leaving certificate. Was
But it is known to be as an
known to the applicant.
Bakrul Islam Mrs. Bakrul Islam.
And why it has not been produced then. Next up. The para giving the para in the application. No, the applicable para in the application regarding the LP school certificate is a para 3 which states the following.
I go to the case court. Para 8 likho. 8 likho.
The above being said,
8.
the examination of the applicant under section 313 CRPC before the learned trial court held on 14/12/2012 shows the applicant's age to be 25 years. Thus, if he was 25 years on 14/12/2012, he would have been born in 1987. The year 1987. There is no stand taken by the applicant during the trial. And even at the time of cross-examination of the witnesses, that he was a minor. Next para. The present application for declaring him a minor has been made 9 years after his appeal had been dismissed by this.
My lord, one sentence if the lordship kindly permits. Here, in this case, Fakhrul Islam, first time in the trial court, he did not take the plea of juvenility. Juvenility, he was not taken. Then he filed appeal before the Honorable High Court. At that time also, he did not take this plea. Then certain years passed. Then he filed a petition before the learned trial court.
Wait. Anyway,
Trial court rejected that, but High Court sent it back again.
that thing. The next para, the certificate,
Para 21.
Already said.
already sent to Supreme Court on 19/5/2025.
No. Para 21 of
No,
Fakhrul
your
Islam.
case.
This case has been sent to Supreme Court. It is before the Supreme Court. So we will record that. By the Guwahati High Court Legal Services Committee, letter number so and so, it has been sent to the Supreme Court. I told you now that there was
That
a
is-
India thing.
That we have no, within not our knowledge.
Okay, so now we know. We will reflect the order
Yes.
and we'll.
In an event of the matter, Lordship, the Honorable Supreme Court may deal with the.
Not only that, but since we have written so much, we show that we have done so much. Come next, right? I tell you, right? The translated copy of the LP school certificate on the page, which is at annexure D of the application. Come on, which is reflective in, I want, which is reflected. Now, which is at annexure, which is at annexure D of the application. Is reproduced here in below as follows, page 42. I take it. Then that. Next. The above be, the further, no, the above being said, we have been informed by the registry that the Guwahati High Court Legal Services Committee has filed letter number GHC LSC /09/2023/98. It'll all be in the order, Mr. Tilak. 98, dated 19/05/2025. Sent the applicant's case to the Supreme Court to be taken up by a legal aid counsel in appeal. Next one. In view of the above, we find that we are of the view that the issue raised hearing can be raised by the applicant before the Honorable Supreme Court. The application is accordingly displayed. Then, IS, you right? In here the order passed in the IS also. These two IS also accordingly disposed of accordingly.
My lord, may we have a copy of the registry's letter? We may,
No, the letter number is here.
That is reflected in the order.
It's reflected in the order. You get a copy of the letter.
copy, if you get the copy, then we will pursue the matter.
No, there will be a forwarding letter. There will be a forwarding. Ah. File, we did so photocopy, maybe you know. Which may be-
But actually, I had no knowledge about this. That's why.
No,
Otherwise, why I will say this? 23 not yet listed in Supreme Court.
huh?
It is sent in 23, but now it's
25, May 25.
April 25.
You remember, sir? You told me it's available.
Nobody is there from HR Chaudhary's team.
Why?
Asa, please, no.
I'm so sorry.
Why do you file the IA for suspension of sentence? My lord? This is the second IMN.
Paperwork is ready, your lordship.
Paper book we have got.
Yes, my lord. The paperwork is there. My lord.
So you are not filing a written objection.
In
Yeah,
terms
na
of.
copy eta diya. Objection file is nahi. Lagi do. We need to file an objection.
In this,
We need to file an objection.
in this IA, my lord, objection is required to be filed.
POCSO.
Oh, sorry,
You're right, Mr.
SS Ahmed.
What is the name?
SS Ahmed, my lord. On behalf-
S.S. Ahmed appearing on behalf of Mr. H.R.H. Chaudhary. Learned counsel for the appellant submits that paper book has been received by him. Ms. B. Buyan, APP also submits that she has received the paper book. Correct?
Yes, my lord.
Earlier, that you can look at. Take the time.
Oh. Next para.
Balance. No.
Was the bail application rejected earlier?
Yes, my lord.
Oh, by which banks?
Miss
In the year
Madam Count is still there.
2022, my lord.
Madam Count and Justice Potato. Anyway, you file your written application.
Yes.
And then in the IA, right? Miss A. Buyan, B. Buyan, if you feel granted 4 weeks time to file written application, the application under section 430.
Yes, my lord. Otherwise, my lord, we are ready for hearing as well, my lord.
Oh, very good.
In the main case, my lord. After vacation, if
The-
possible, my lord.
List the matter same day, give a date, huh?
When a notice has been issued to the other side,
What about
What's the
that?
matter?
Yes,
No
yes,
notice
yes.
has not been.
no notice, then it should be issued, no?
You guys the main application.
Oh, Hollywood.
Main application.
No, put to account. This is good. No.
Right,
Xerox page, where it is?
in the main appeal.
Office.
No notice has been issued.
Main appeal. Notice this page. It's
Self-confident.
just an issue, sorry.
No, notice was issued, but no steps taken. No, there was no, informant is not a party here.
My lord, in the main appeal, my lord, there is informant is not made party. So it's
Right.
matter of 2022, my lord.
In the present case, the informant has not been made a party. The matter pertains to the conviction of the appellant under section 6
Yes, my lord.
of the POCSO Act by judgment dated 11/3/22.
Right.
But it's very. It was so.
Okay, right, third miss.
Hell.
Did you know Lovely Devi?
Yes, Lord. Yes.
You're Lovely Devi, okay. Oh, okay, I knew only a L Devi. Okay. Yeah, Assamese.
Yes, Lord.
No, because the name Lovely, Pinky, and all this.
It's also
Huh?
Budget.
Sir.
in all the communities.
I had a friend. Hey, Khaled, 30. Name is Pinky.
The common names.
Uh,
Bobby.
This joke is there, no? The joke is there. This third here, taking two dogs associates for a walk. And friend of his, I mean, like acquaintance met him. Nice dogs. What are the names? Oh, Jaswinder. Anyway, lovely university is there also in Chandigarh.
Yeah, yes, Lord. There is a lordship in Assamese. I don't know in other communities. Like, Tera naam mein kutta palenge. Lordship, relationship deteriorates, then only. Legal aid council.
The legal aid council for the applicant submit that there are 115 days delay in filing the application against her appeal. And against her conviction in an appeal, in the appeal petition.
He's not here, so.
Under section 302 IPC. Ms. B. Boyan, additional PP, Southern Section, but no objection to the delay being found. According to the delay of current case found, registry to list the appeal. I is accordingly disposed.
Okay, that's a question.
May I please your lordship? Lordship, there is delay of 126.
Notice.
Yes, lordship, notice may be issued.
Heard, Mr.
You Ghosh, lordship.
Huh?
You Ghosh on behalf of DP Boran.
You
Ghosh.
voice appearing on behalf of Mr. DP for learned counsel for the applicant appellant husband. Submits that there is a delay of 126 days in filing the appeal against the rejection of his petition, against the dismissal of his petition for divorce.
Lordship.
Issue notice returnable in 4 weeks. Applicant to take step for service of notice from the respondent by speed post
Lordship.
within 2 days. This is the matter. After, this is the matter, give a date. All date, all date. Not just give date.
Deeply obliged, lordship.
One more day.